Yes, Ms. Markham.
Good morning, my lady, my lords. If I just may introduce the parties to you and deal with some housekeeping to begin with.
Yes, we've got rather more parties here than I was expecting.
There are a lot of people in the court. I'm just going to introduce counsel.
Yes.
That is, if it's okay.
Yes, absolutely.
So I appear on behalf of the appellant,
Yes.
Liverpool City Council, with Miss Target Parker, who sits behind me. My learned friend, Mr. Sampson of King's Counsel, with Miss Johnson, appears on behalf of the mother. On behalf of the father, my learned friend, Miss Kavanagh Casey, with Mr. Haggis.
Kavanagh.
On behalf of the children, my learned friend, Mr. Stoner, King's Counsel, with Mr. Senior, and Mr. Senior's pupil, Miss Qureshi.
Yes.
Just to confirm as well, the father of the youngest child confirmed yesterday that he doesn't have legal aid, but that he supports the appeal. In this matter, we've been discussing how we refer to everybody for the anonymity.
Sorry, but have we got counsel for the second respondent and third respondent?
No, that's why the second respondent confirmed that he
Good
doesn't
yesterday.
Have yes.
Supports the appeal, but
Yes.
not represented.
Yes,
Hasn't
and-
got legal aid.
Yes, and I don't have any updating information about the other father.
Fine, thank you.
Okay.
No, it was just that rather unnervingly on our slips we had counsel for both the other parties and we were wondering what they would be able to contribute.
Well, they're not. You have the three.
But they obviously thought the same.
Yes. In this matter, of course, we're focused on a sibling group of three.
Yes.
But the primary application is in relation to the middle child, who my Lord Moylan referred to as C. So I had been referring to him as C. Others, somewhere in the skeleton arguments, called him AC, but his father's also referred to AC. So without any disrespect to the parents, I propose to refer to C as C, his mother as his mother, and his father as his father. Others may refer to his father as AC to differentiate, and I refer to the siblings as older and younger siblings. That is how I propose to deal with them, my lady, my lords.
Well, perhaps we can deal with that and do that across the board if that works for everybody else.
Thank you. Apologies also that first thing this morning you were sent two updating
We
documents. I hope that my lord, my lady, you have those. I will be referring to each of those. So it is the
authorities,
Yes, the Hague extract from the practical handbook and the full detail of the Hague 96. You have, of course, some of those set out in the authority bundle. There is just one issue that my learned friend, Mr. Sampson, King's Counsel, wants to address you on in relation to the mother and the interpreter. She is, I think, attending remotely.
Yes, Mr. Sampson.
My lady, my lords, thank you. The mother is, as you've heard, attending remotely.
Yes.
She has the benefit of an interpreter.
Good.
We found out only this morning that the interpreter arranged, rather than being the interpreter who had assisted her in understanding the proceedings and in conferences, was in fact the interpreter who had interpreted her evidence at first instance. That is, I'm afraid, something we found out very late. No party raises any objection to that, but we felt it entirely proper to let the court know.
Well, thank you. Any objections? Not a problem, sir. Not a problem.
Is she able to see? There's no screen.
Yeah, we can't. Is she not supposed to be on the screen?
Well, I raised the same. I understand that she is following, although I appreciate there is a brief delay, on the live link. That is the arrangement that was set up.
Fine.
Fine.
Thank you.
Yes,
Yeah, thank you.
yes.
She's just watching on the
Yes.
Yes,
Yes, sure.
whatever it's called, live stream.
YouTube. Yes. Thank you. Yes,
So,
Ms. Markham.
my lady, my lord, I therefore just need to remind myself at intervals that this matter is being interpreted, so to slow my pace a little more than perhaps I did. So if anybody wants to alert me to that, I'm happy to be told to slow down. These are, of course, an appeal in relation to a order made by Her Honour Judge Coppel. You have now quite a few skeleton arguments before the court setting out the background to the proceedings, so I don't intend to open it in any detail.
No, we have all had the opportunity of doing extensive reading in this matter. So we've read all the skeleton arguments. We've, of course, read the judgment. And I think I'm not just speaking on behalf of myself, but for all of us to say that we have read extensively into the supplementary bundle as well.
Thank you. Well, my lady, my lords, I think it's right that I first of all address you in relation to the points taken by those who support the appeal, to confirm for the record that I adopt all of those points taken on behalf of the mother through those who represent her in the skeleton argument, and on behalf of the child by those who represent her. I am not going to trespass over and repeat those points unless my lady and my lord have any particular questions regarding the authority. I, of course, and Ms Target Parker, when she prepared her skeleton argument, didn't deal with the point that my Lord Justice Moylan raised in relation to Article 33. So may I just start by looking at that point, my Lord?
It was just an idea. I'm not sure that it, as the way the case has developed, that there are any issues that are raised. But anyway, yes.
Well, I was looking at the, and I don't want to steal his thunder, but the point raised by my learned friend, Mr. Stoner King's counsel, at paragraph 13.38 of the Practical Handbook, which I'm just going to turn to now, which is the...
Sorry, you're going to his skeleton or the handbook?
The handbook.
Sorry, which paragraph number?
13.38.
Yes.
And that encapsulates the discussion as to the scope of Article 33 and whether or not it would apply to placement of children within relatives in the contracting state. But perhaps it's the point that comes in the end of the fourth line. Other experts express concern that should such measures fall out of the scope of Article 33, there would be no obligatory safeguards in place to ensure that the contracting state in which the child is to be placed is aware in advance of the child's relocation to that state, and to ensure that matters such as immigration issues or access to public services had been considered and resolved in advance of the child's move. And my lady, my lord, the reason I come to that and highlight that point is one might argue that that is apt in this case, because the local authority argue that there was very little information about management of risk were C to be placed with his father in Italy, and how the support services might be put in place to manage that risk and the contact arrangements. So whilst it might be an interesting point to argue whether or not Article 33 applies, we say that the handbook has actually identified the actual issue in this case, that because there was the lack of clarity and guidance around the communication between the states in order to provide the necessary information to the judge making the welfare decision, the learned judge fell into error. And of course, one may say that it's all very well in hindsight to say that guidance may have assisted, but one of the issues that this appeal brings to the fore is how information is gathered, how the steps are taken during the currency of care proceedings, in particular in a case where there is a very clear factual issue to be determined as to the issues of, so in this case, domestic abuse and other issues such as dishonesty and the way in which a parent might engage with professionals. Now, of course, this local authority liaised with the CACU, and steps were taken, I submit, quite properly under the understanding of the way in which information should be shared. And I've just confirmed, because not being counsel at first instance, I needed to be clear when I was making submissions, that the bundle as it was in existence was sent to the CACU on the 29th of August, 2022. And I'm very grateful to my friend Ms Johnson, who's just confirmed this for me. On the 15th of September 2022, the CACU requested all of the documents, which included the threshold with the allegations in, to be translated. They were sent on the 28th of September, translated. And then you have some of the emails that were sent in the main court bundle, including that later on along the process, a template, parenting assessment template, was translated into Italian and sent on to the authority, and that's at 372 of your main bundle. And I'm using electronic numbering, I hope. And again, my apologies and thank you to your clerks for assisting with the formatting, because I know that the index was out and that's not helpful.
Page 372.
372.
372 is the email,
Yes.
not the document.
No, it's not.
Okay.
It's just the email saying. And of course, what is interesting, if my lady and my lords look at the next page, the liaison that was taking place with Okaku in this case was, as you can see under the head note from Miss Boniface, the case manager, predicated under an Article 33 request. If you see, it's there,
I
Hague
see.
1996,
Yeah.
Article 33.
Yeah.
So, in some ways, this local authority was, and Ikaku were, treating this as an Article 33 request. But the lack of guidance for, it seems to me, anybody on the ground as to what material should be properly sent, what questions were being asked, so that the court in this jurisdiction could manage that and case manage that. Because I've gone back and it doesn't seem to be it was case managed in that way, so that the court in this jurisdiction had some certainty as to the proper questions being asked of the receiving state. That doesn't seem to have occurred. So there does seem to be a lack of understanding on the ground as to when you would use Article 33, what questions should be asked. So, and the reason I start with addressing this is because we say that the difficulties that then arose, and arose in any event from the paucity, and I don't say that in a pejorative way, it was a very superficial assessment by the Italian social workers on any reading. And they arose because perhaps the right questions weren't asked at the right time.
Well, help me with this, because I certainly hadn't picked up in my reading that a parenting assessment template had been sent. It might be helpful, actually, if we get given a copy of that, not this minute, Miss Markham.
I certainly will ask for that, thank you.
Because clearly that was not then used by the social worker who visited the family, the father and the grandmother.
Yes.
But also, it's apparent from references in the Italian social worker's evidence that she didn't regard what she did as a parenting assessment either.
No.
Because there's a reference to if we have a parenting assessment, or we could do a parenting assessment if requested, and so on and so forth. So it seems that what happened actually was neither the parenting assessment in the format that was anticipated by the local authority, they having sent to the Italian social workers their template they wanted used,
Yes.
and the social worker making it clear that actually a parenting assessment Italian style, if I might put it like that, was a different animal from that which she actually conducted.
And of course, to be fair to the Italian social worker, it's made plain in the report that she sends in. If you turn to page 280 of the electronic bundle,
Tab 15. Yeah.
this is what's called the final report. The penultimate paragraph, furthermore, Mr. F, for example, if they will be required to cooperate with the family centre in order to assess their parental capabilities as ordered by the competent authorities. And what I think is also clear from the transcript of the social worker's evidence is that Ikaku did not send on the relevant material. So
they didn't send on the parenting assessment template?
That's what we understand.
And
when
of
you
course
say that's what you understand, is that what Ikaku said? Because it's slightly puzzling if they'd asked for it in translation. And it may have been sent to the Italian Central Authority and then not sent on, or...
It was sent on to the Italian Central Authority. It seemed to be that the social worker didn't receive it. I can put it no more than that. I'm not able to say...
Well, she didn't use it, so we don't really need to investigate.
No.
And of course, because the finding of fact hearing hadn't taken place as originally anticipated, what puzzled me when I first came to my reading was how come there hadn't been a finding of fact with all these very serious findings against the father, which was then communicated to the social worker who was conducting what turned out not to be a parenting assessment.
Yes. And of course that is the central component of the appeal, is that the learned judge fell into error in, and it's dealt with in various different ways between the local authority, those representing the mother, and those representing the child. And I don't mean to cut through it, but that's the central argument, that there were significant findings made in relation to the father. And there can be no criticism of the Italian approach because they simply didn't have those findings. And it was open and proper for the local authority to say they are so significant that we say this is the right outcome, and for the guardian also to say that. I have to accept it was open to the learned judge to say, well, I need further information. I need to adjourn. And I accept that that wasn't an application made by any of the parties. And I stand by the local authority's primary position that the findings were so concerning, particularly around manipulation, dishonesty, and the complexity of the relationship between C and his siblings and the parents living in different countries, that it was right, and the delays incurred. And when one reads the anxiety that C was feeling around his placement, that it was perfectly proper for them to invite the court to make final orders. But I have to accept it would also have been open for the learned judge to say, I made these findings, I formed preliminary views about the father, but they need to be assessed.
How long would that have taken? It took 47 days over 10 months in any event.
Yes. Well, my lord, that is why I say it was perfectly proper for the local authority to say they are so serious, we've been so long, the prejudice to the children outweighs that assessment. I don't know how long it would have taken. There are different ways it could have been undertaken, either through ICACU and the assessment in Italy, or we know the father came over here regularly. He could have come over here to be assessed within this jurisdiction.
Which is not uncommon.
It's not uncommon. So
because that the house had already been seen.
Yes.
The grandmother met. So a full parenting assessment could have taken place over
yes,
here.
Absolutely. So I have to accept that could have been undertaken. And the difficulty around that is what would that have brought to the full welfare analysis? Because what we know is, notwithstanding those findings having been made, and the fact that they are not to be appealed, the father doesn't accept them. So where would that have assisted any professional in assessing risk when there's no insight and he doesn't accept them? So the local authorities say that that is why their position was taken as it was. And of course, this is an unusual case in that 47 days of evidence, change of social worker, Ms. Miles, who wrote the final document, sits in court today, was perfectly entitled to form a different view, having heard all of the evidence as well, and to provide instructions as is ordinarily across the scope of such extensive, well, even if it were 4 or 5 days, as was the Guardian. And you have the Guardian's final position statement, and the Guardian is very clear that they were listening to and considering the evidence. So we say that the steps that the local authority and the Guardian took, and I'm drawing them together in relation to reviewing and thinking about and listening to the evidence, was a perfectly proper way. But of course, one of the issues in this case is the degree to which the learned judge fell into error when she directed herself, which I say she did on 2 occasions, and they are at paragraphs 282 and 307 of the judgment, that it would be unthinkable. I will just find that reference. Paragraph 287 is at page 115, electronic page 115.
287.
Yes. I'm sorry, I'm giving you the wrong reference.
I
reference.
don't think you mean that.
113, thank you.
Paragraph 113.
Yes. No, page 113.
Oh, can we get paragraphs, please?
Certainly. It is paragraph 282
Thank you.
of the judgment. I've conflated, it's 282 and 307, and I mixed up the numbers. I'm so sorry. So 282, if you see the 4th line, it is unthinkable that Antonio should lose his relationship with his father. And that word is repeated.
Can you just,
Yes.
just stopping there.
Yes.
Nobody was proposing that he should lose his relationship with his father.
That,
And you did just mention his name. But
I'm so sorry.
that wasn't what the issue was. Nobody was suggesting he would lose it. So it's a mischaracterisation in any event.
Yes, and that's repeated at paragraph 307.
The
Because
same formulation.
the same formulation.
Yes.
And of course, as my Lord Justice Moylan, you've just pointed out, the question of contact and that ongoing relationship was something that the learned judge should have given weight to, the balance within that relationship. And we say that that phrase that's repeated twice within the analysis section of the judgment identifies where the learned judge fell into error.
Sorry, I distracted you, I think, from the submission you were going to make. You were going to make a slightly different submission,
Well,
but I'm afraid to say I didn't write down. So
I was making the submission that we know that the learned judge had fallen into error in the way she was considering and assessing risk by starting off with what she found to be unthinkable of the loss of the relationship, rather than conducting the holistic analysis, which might include how the relationship could be protected and supported. And also, it fits to the primary submission we were making that identifies where the learned judge was reviewing having to manage this case on the evidence that she had at that point in time, rather than standing back and thinking, do I have sufficient evidence? What happens now in relation to the findings I've made? What do I need to do with them? And it may well be that the learned judge was concerned about delay, the extent and the breadth of the proceedings, the life of the proceedings, the age of the children. But she doesn't deal with that. She doesn't tell us, I've had to balance in this case, adjourning for further assessments. There's nothing in that. There's nothing in the judgment that suggests she even paused to reflect upon that. And we say she fell into error, particularly when that was identified through those representing the local authority, the mother and the guardian. I'm trying not to repeat everything that's been said because, of course, you have a lot there and I know that you've read it, but I just wanted to...
But if you go back to just 282 and the sentence that you highlighted, the judge there is saying the balance is between unthinkable Lou's relationship with his father, which is so positive, and then in favour of foster placement relationship with... So it's a false... You're saying it's a false balance.
Yes, yes. It's the linear approach that judges are very much cautioned against undertaking. And we can see that throughout the judgment. There are other paragraphs where the learned judge, well, I've ruled out mum. I've now looking at foster placement. I'm approaching this by the unthinkable option, and therefore I must look at that option. And that's the wrong way to go about it. There are many different factors in this case. It's an unusual case. It relates to parents that live in different jurisdictions. It relates to relationships with siblings who are in different placements. It relates within the ambit and scope of the holistic analysis to risk assessment, what that might mean for all of those ongoing relationships.
Sorry, say that last point again.
What that might mean, the risk assessment for all of the ongoing relationships. And they are dealt with in all the different skeleton arguments. And by that I mean, what does it mean for contact between C and mum if father is managing that with the findings that have been made? What does it mean for C and his relationship with his younger brother in light of the findings made? What does it mean around the ability for M to travel to Italy? What would that look like? What would it look like for the older sibling and the younger sibling? How are they managing that relationship? Particularly when the older sibling remains in the foster placement, which we know C is very much embedded in. All of those are complex and difficult matters that ought to have been looked at in a holistic way with an evaluation that wasn't simply, I've got A and B as outcomes.
And you're saying they're completely absent from the judge's analysis of the benefits of placement?
They're not completely absent. That would be wrong for me to say that. What is completely absent is the analysis of risk. And I say that is detrimental and runs a hole through the judgment. Because if one looks at the holistic analysis, we look at the welfare checklist, risk is a central component. And you have to, when we look at HW and REBE, the Supreme Court decisions, you establish the factual nexus, then you look at what that means for risk, then you put that into your evaluative holistic analysis within the range of options. And absent the proper evaluation of risk within the framework of the findings made, how can the learned judge go on to undertake the evaluative analysis that she does?
Could you expand on risk of what?
Well, the risk of harm to C in light of the findings made.
And Miss Sampson, no doubt, will deal with this to flag it up so that
Yes.
so that he knows that I'm concerned about it. Is we have all these findings of fact. You know, the judge had a hugely challenging task.
Yes.
But where we get what I don't think I'm seeing, I'll be put right, is. Oh, beg your pardon, Miss Kavanagh. Mr. Sampson would. Sorry about that. Is that the findings are that the little boy's relationship with his brothers, and no doubt further submissions can be made about that, but that's a fact. The fact that the primary carer had been the mother.
Yes.
That the child had could only recollect living in this country. That the child had been with the foster carer for something like 2 years by now,
Yes.
was not only settled, but the foster carer had become the psychological parent.
Yes.
And that the child had suffered significant emotional harm at the hands of the father in the given the findings that were made, emotional harm, not physical harm, because having been present when the mother had been the subject of domestic abuse and so on. So, and that the child doesn't speak Italian, and had visited but didn't speak Italian. On the other hand, that there's a father who has kept in regular contact, clearly loves the child, wishes to offer the child a home, but has had very serious findings of domestic abuse, manipulation, etc., 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 made against him. Now, and then it seems to me that then when you've got that, that's the backdrop.
Yes.
That you then start conducting your risk analysis.
Yes. Yes. And that's absent, we say.
That,
So it's not just risk of abuse in Italy, it's risk of losing a stable relationship with a foster
Yes.
carer in the UK.
Yes.
There's very little about the foster caring relationship in the judgment. I just note, I think it's paragraph 307, where there's a sort of a systemic criticism of foster arrangements with all their well-known disadvantages. There's no analysis in the risk-reward ratio of the actual loss to the child of being moved out of the fostering relationship.
No. The focus is on the impact on the sibling relationship. The two siblings are together, but not on, therefore, the relationship of the foster placement itself. So there are a number of matters that we say ought to have been properly considered within the assessment of risk that simply weren't.
as I understand it, I'm not sure we really get it from the judgment, that the foster carer had offered a long-term fostering placement.
Yes.
It wasn't one of those cases where the little boy was going to have to be moved in any event.
And what is plain an example of the evidence that was before the learned judge, forgive me, I've been reading a lot coming into this, I believe it was in the position statement filed by the Guardian towards the end of the proceedings, was exactly that relationship and the concerns that C had about the loss of that relationship. And they were quite powerfully put on behalf of the child, but not dealt with by the learned judge at all.
So, I'm sure you're coming to this, but where then do we get the fact that that didn't happen then? How much of that, in your submission, was a consequence of the judge effectively having a presumption in favour of the natural parent?
It's a submission that can be properly made on the papers, that the learned judge directed herself in that way twice. It's quite a powerful way to direct oneself. And we often find cases where a decision is made, and it seems to have been made, not quite often, I think that's probably a misstatement. There are some judgments that we see where judges reach a conclusion and find the evidence to fit in behind it. that is the sense of reading this judgment, that the learned judge reached a clear decision that it would be unthinkable for C to lose that relationship, and fell into error and didn't then say, but I must caution myself. I must then have regard to A, B, C, D, all of the components of risk, relationship with carers, relationship with parents, change of dynamics, loss of sibling relationships. And of course, one of the things that also happened in the judgment is that the learned judge said, well, having found that the father can provide care, I now look at the loss of relationship. Well, that's the wrong way around of doing it. It's a holistic analysis, not a linear approach. And the learned judge should have stood back and had regard to all of those factors. She was being invited to by both the local authority, the guardian, and the mother. And you know that from the reading of the judgment. She sets out and refers herself back to the final analysis by Miss Miles, the allocated social worker, to the guardian's analysis, the change of perception on the evidence they have had, but doesn't caution herself in any way. And it is plainly set out when one looks at the judgment. I just will take you to those paragraphs. It starts at paragraph 284. Actually, 282 at page 113. And it's not simply the phrasing of it's unthinkable. The first sentence of that is, there is a realistic alternative for C, which is placement with his father. And although I recognise the deficits in F's character and the previous violence, I am satisfied these matters can be addressed by the involvement of Italian social services. Well, evidentially, on what basis does the learned judge reach that?
Well, that requires honesty, cooperation,
yes,
etc.,
yes,
etc.
and requires a basic primary parenting assessment within the factual frameworks of those very serious findings. So it was, and we accept, open for the learned judge to say it's a realistic option, there are some very positive parts of it that form part of the balancing exercise, but there are still some other competing factors that I must have regard to. And one might say, even if the learned judge had got through all those assessments correctly, had looked at all those competing values, had looked at the relationship with the foster care, had looked at sibling relationships, mother's relationship, that second part of that sentence, satisfied these matters can be addressed by involvement of Italian social services. How? The allocated social worker, yes, gave evidence that there could be the parenting assessment. I've taken you to that referral in the report. And in the evidence said there could be some psychological support. But that social worker didn't know the framework of the findings. So how could that social worker then address the court on the support services? And of course, and I know that Ms. Target Parker made these submissions at first instance, there was a real risk in this case that C goes over without those proper transitional provisions or assessments being in place, to then be put in institutional care whilst assessments are undertaken. And whilst I know that Ms. Kavanagh Casey says that's speculative, I repeat that submission because it must have been a proper concern for the professionals, because these are very serious findings. So we also say that second part of the sentence indicates where the learned judge fell into error, because she simply didn't have sufficient evidence to satisfy herself of the involvement of Italian social services. And this is where we come back to the issue about information sharing and what the first instance judge should have, that I looked at that part of the handbook, because that does seem to provide an added route map and security for a judge at first instance to make sure that you not only ensure that the right paperwork is sent, but you are entirely satisfied that if you are, as this learned judge was doing, sending a child into another country, when a framework of orders, because there were some orders that were necessary as well, should they have been advanced mirror orders, should there have been advanced determination of all of that, as some of Hague 96 suggests that one should do, but also what are the provisions in that state that the state is able and willing to provide in light of the framework and the judgment.
So tell me, I doesn't presume anything. So if the order having been made, had it not been subject to appeal, and that was going to be then what
Yes.
happened, would the local authority then send copies of the judgment and various documents to the social services in Italy?
Yes, I think that was the.
For their,
Yes.
that's what would happen.
That's what we do.
They would
Yes.
then, as part of the relocation
Yes.
arrangements, because of course this child's in care at the moment.
Yes. There was the
She says it-
transitional plan.
It says in 307 she'd make a registrable care arrangement or
Yes.
enforcement
Yes.
in the Italian court.
Yes.
But I just wondered about documents,
Documents,
and
yes.
what, receiving the judgment and so on.
You could make the same submission if the judge had been referring to local authority here. You can't just say can be addressed by the involvement of. I mean, we all know cases in which it's said that local authorities will be able to manage the risk of placement with a relative or a parent, and the judge concludes no, they won't, because of you need cooperation, engagement. But so that you could, it doesn't. I mean, it doesn't. It's not that it's Italian social services. It's social services. It's too bald a statement.
Yes. My learned friend Ms Kavanagh Casey, on behalf of the father, rightly points out that it would be the same if the child was being placed in another local
Yes.
authority. But that is absolutely the point. And that's why we have the process and procedures. For example, if another local authority is to take a care or supervision order, we have clear stages that we follow to ensure that that receiving authority, if I can put it that way, are satisfied that in light of a judgment that the services they're being asked to provide are appropriate, and can they, and they're entitled to make submissions to the court to say yes or no, or even as to the appropriate order that should be put in place. So again, that is where we say the learned judge fell into error. So there is, of course, agreement or the no appeal against the findings. It's how she applied the findings and all of the information she had to the welfare checklist. And each of those who support the appeal have in their skeleton arguments looked at the distinct ways in which it submitted the learned judge fell into error.
When you say the findings, you mean the findings made against the sort of historical findings?
Yes.
Because I mean, whether it's analysed as a finding or not, you're not saying, you're not accepting the finding made that, for example, the I can't remember what it is, that the relationship with the mother and the elder sibling will be maintained through contact. That's an evaluation, not a finding.
Yes, sorry, I'm trying to separate between the, if I can put it this way, the threshold document, and
Yes.
the findings as to honesty and behaviour, distinct to the welfare evaluations and findings within that, and almost drawing a line between the factual framework that leads to the final threshold that starts at 1, 2, 3 of the bundle, but also, of course, in many ways, the learned judge goes beyond that in some of the findings she
Sorry,
makes.
when you're talking about
Yes.
the findings aren't being challenged, you're talking about the threshold findings
Yes.
as set out
Yes.
in the, is it an annex to the order, whatever it is?
Yes.
1, 2, 3 to 1, 2, 5.
Absolutely, and also as embedded within the judgment about the father's dishonesty, and that is highlighted by those of us variously within our skeleton arguments.
Right, okay.
Mother addresses those at pages 534 to 5, the guardian at paragraph 5486, and even Miss Kavanagh sets out the framework of the assessment of her client. There are a number of issues that Ms Kavanagh, on behalf of the father, flags in relation to whether or not the appellant skeleton argument is made out or strays into speculation. But I'm not going to respond to each of those because, of course, the heart of this appeal and the point of this appeal is that's entirely what the learned judge did. She strayed into speculation around what the Italian social services would do with her judgment. And there needs to be an element of speculation as to what might go wrong in order to highlight and evidence the failings and gaps in the analysis undertaken by the learned judge. And we accept that some of those can be characterised as speculation. We don't know, but that's the point. We don't know what we're happy to see when he's sent over to...
Well, that's all about an evaluation of future risk.
Absolutely.
That's what judges do.
Yes. So I'm not going to go through and deal with those points. I accept that they can be categorised as speculation.
Well, one of the things you might need to consider is in looking at the pros and cons, and the judge has focused on the long-term foster care. But what would happen if the placement with the father didn't work or broke down?
Yes.
Did anybody make any submissions about that below or not?
I think the submissions were made that one simply didn't know how the Italian social services now approach the placement in light of the findings.
I see.
And so one didn't really need to go further than that. There were submissions made about what happens if contact breaks down, and I use that term globally. Within that, there is the relationship with and contact with younger brother, older brother, and mother. What happens if that breaks down? Submissions were made about that.
What about the child be caught up in discord between the
submissions were made.
parents?
Submissions
Yes.
were made about that, and of course, a particular issue in this case was the recent events when the child went over to Italy and the parents restarted a sexual relationship and the concerns arising from that. Submissions were made by variously the local authority and the guardian about the risks if the mother went back to Italy in light of the findings made about her. So there were a number of factors that were raised before the learned judge that were sufficient, we say, for her to have paused and reflected upon them and asked herself the question. Well, she does ask herself the question, this is one of the difficulties, do I have sufficient evidence? And she says, I do, because I can fill in the gaps. And we say she then fell into error as well, because she didn't have the evidence to fill those gaps in. And perhaps it is because, when we submit, she had formed that view in her mind that it was unthinkable that the placement shouldn't happen and that there might be that loss of relationship. And that was a stumbling block she kept coming to. It's unusual to see that language in a judgment and for it to be repeated twice, but it gives a very clear indication of the judge's approach to this case. So there were a number of issues that both the local authority and the guardian, I suspect to the mother's team, I don't want to trespass onto what Mr. Sampson might say, were made in terms of final submissions about the real concerns about C's placement. A whole variety of matters that the learned judge really needed to think about. And recognise entirely that, my lady, my lords, you may form the view that what should have happened was an adjournment at that point in time. But against that, as my Lord Justice Green has pointed out, that there is the concern and the risk of delay. Because if a child is placed in foster care, there can be these ongoing assessments within that framework. You could conclude the proceedings, and there could be the ongoing assessment. See what happens through ongoing contact, see what happens through ongoing risk. What if the father shifts and begins to show some insight and accept change? What would that mean under the LAC review process? Of course, the starting point in this case, and I understand it is the position, and I hope that somebody would have jumped up by now if I'm wrong, the father doesn't accept the findings. So where is that going to take any risk assessment? I've gone through quite quickly oral submissions because, as I said when I started out, a lot of detail in the written submissions. Some of the points are amplified or put in a slightly different way with slightly different emphasis by the mother and the guardian, and we adopt those. I don't want to be speaking for the sake of being speaking. Of course, if there are any other questions that I can assist with at this point in time.
No, thank you very much. That's very clear, Mrs. Governor. Now, I think probably, in fairness to the father, we should hear Mr. Sampson next. I don't know if you'd made other arrangements, so I apologise, but I'll hear you next anyway.
Precisely what we had made. We suggested, I believe, that the three effectively supporting...
Oh, no, we'll have the Guardian last.
Thank you. My lady, in that case, certainly I will speak next and say relatively little for this reason. So often one hears said or discussed these submissions one's going to make, so I will try not to repeat what's already been said, but may I, in an effort I hope not artlessly to condense the essence of this appeal, put it this way. Firstly, my lady's observations earlier. This is a case where clearly there should have been a fact-finding. There needed to be one. The pervasive issues in this family, spanning a number of years, with patterns of behaviour that had affected all three of the children, of which I accept my client was part, required a fact-finding hearing. This was not a case in which, as we see sometimes, there could be, if you like, a contingent risk analysis done very easily at all. And that was further hampered, of course, by the geography of the case itself and by the need to assemble information from a number of different jurisdictions. My lady, the judge was clearly in an invidious position at the end of the previous year, where she was invited to adjourn by the father for the older child and had to do so. And one well understands her urge to, if I can put it this way, put her foot to the floor a little in proceedings which had been dogged by delay. But nonetheless, the way in which that was handled, and this is perhaps a collective failure rather than one that I advanced saying that the judge should have picked it up. My lady noted, and this is the point, there was then no step taken to buttress or increase the information from the assessment of this child's father. And in fact, that need not have been an assessment simply conducted by Italian social services. We were not dealing with a jurisdiction where the only way this could be done was by workers in that jurisdiction. This was a father who was, of course, coming across for regular contact, who was seeing the local authority social worker. And it was quite open to the court to require a further assessment. The thing that caused the problem was perhaps unforeseen, because my lords, my lady know that the local authority's original plan was that if these findings are made, then frankly this case is quite clearly swinging in one direction and we will be pressing for these children to remain in foster care. But if findings are not made, then we are looking instead to a placement in Italy. That's changed, and cases do change. Cases change as a result of oral evidence given or further events before the final hearing. And it is no criticism of either the local authority or the Guardian for changing their positions as they did within the final hearing. The problem that left the learned judge in is that she then, if she wanted to depart from that, didn't have the information that she needed, we say, in order, as we put in our skeleton, and as has already been said orally today, to plug or fill in the gaps. The reason I say that, and I hope not repeating myself, is that the ebb and flow of relationships within this family, and my lords and my lady have seen the way in which these children were moved and the dysfunction to which they were exposed. Those uncertainties had pervaded these children's lives. And there was a real need to burrow down into the risk of repetition. And there is no evidence as to the risk of repetition. And my learned friend Miss Kavanagh, on behalf of the father, says, well, the judge was entitled to take the view that the father's lying and manipulation, as she put it, both to the court and in the past, was not one that would then necessarily play out in his dealings with both professionals and in contact in the future. She may be right. The difficulty is the learned judge didn't know, and didn't, if I may say so, have any information on which to base her positive prediction that he would be cooperative. The most that she had, and it was insufficient, was that the fact that the father had undertaken the assessments required of him in so much as they were assessments within proceedings and had cooperated with contact and had given evidence to the court that he would comply with the requirements. But of course the problem with that, without straying into Lucas direction territory, is that the learned judge was entitled to depart from that, but she needed something. She needed something solid. And what she had was her own finding that within the court's own four walls, within his evidence about this family, the reasons they were there, he had lied and attempted to manipulate, all including her. My lady, my lords, therefore I say that this is not an appeal that the judge got the balance wrong. The appeal is A, the learned judge did not conduct an adequate balancing exercise at all. And B, and of course it's linked with this, that she didn't have the necessary information to consider confidently or at all the risks flowing from repeated patterns of violent behaviour, the consequences of his refusal to accept the allegations against him vis-à-vis future work with him. In fact, there would have been, as far as one can see, no future work with him, because this would have been a child arrangements order with an entirely unclear plan about what support would be offered. And 3, of course, his ability to support the family relationships that, and my lady has made note of this, as do I, on behalf of my client, were so crucial to this child's future. One of those, of course, was his relationship with his mother, and those on behalf of the father say, well, he wasn't saying that he wanted to see her as much as the local authority had sought, which was weekly. He was still seeing her and would see her fortnightly in foster care.
One of the things I should possibly have asked Ms Markham, I don't know if you can help, is whether the judge had information before her about how exactly how contact would be managed. I think that the child with whom he's currently living, who is remaining in the foster placement and is subject to a care order, that money would be found to facilitate contact on the basis it was contact between siblings.
Yes.
But of course, that would come to an end. Obviously, the local authority wouldn't pay for any contact on that bandwagon, if I might put it like that, once that child became 16.
And there is an age gap there. And subject
Exactly.
obviously
So you're talking about, and the father, of course, is out of work, but you're talking about
a handful of years rather than the entirety or the large majority of, forgive me, the large part of this child's minority. Yes.
I just want to be clear factually rather than sort of draw any conclusions. But yes, am I correct in my understanding?
My lady, that is certainly my understanding, having read the papers I have. But of course, I also did not appear at first instance. So would my lady forgive me if I turn my back briefly to check? Thank you. Yes.
Thank you.
My lady, the next issue to which I return briefly is this. How did the judge apply her own findings against the father? That is the question that was raised earlier, I believe, by this court. The issue for me is whether she did at all. Part of the welfare exercise under section 1, subsection 3, F would of course be, E, forgive me, the harm suffered or that the child was at risk of suffering. And one does look, if I may say so, in vain for where that is, having made her findings on the matters that she was required to consider as part of threshold. The learned judge does not, save to say, and I'm paraphrasing, I think the father will support this package. She doesn't go on to consider those risks. Now, it was open to her, of course, to consider that they didn't arise in the future, but there isn't, in fact, a recording of or analysis of it at all. Without, I hope, straying into a critique of the terminology in the learned judge's assessment of the father, although she does not say so, there are elements of this case where it is as if we are looking at a case where the care plan is for adoption. Of course, the learned judge is at pains to point out the potential shortcomings of long-term foster care. But when she describes, in fairly stark terms, the loss to this child of his father, and it's a point that I believe my Lady Justice King raised earlier, she talks of it as if that relationship will not be continued. The purpose, after all, of the local authority's care plan was to maintain and strengthen this child's relationship with his mother through very regular contact. It was to allow this child to grow up with a half-sibling who was described in the Together or Apart assessment, and indeed it was common ground, and a solid relationship with his older half-sibling, to whom he looked not only for guidance, but for support on a day-to-day basis. And of course also with the father. And I fully accept that that would have meant a relatively infrequent level of contact. But I remind this court that the father had been coming over, I hope I have this right, monthly. What wasn't explored, what could have been explored by the learned judge, if she felt that level was far too low, was inviting the local authority to amend its care plan. Or for that matter, if she wished to do so, making a Section 34 order, directing the local authority to provide a greater level of contact. That, for obvious reasons, because this is effectively an either-or equation for the judge, is not something that she looks at all as an alternative, which would, of course, have allowed this child to remain where he was. I note, because it's also missing from the judgment, I think, but if not, I certainly missed it when I read it, that this child was also going to be having regular contact with his younger half-sibling. That would have been as part of inter-sibling contact, I think, I'm right in saying, once a month. But also, when one looks at the background, he had a meaningful relationship with the father of his younger half-sibling. That too, I'm told by Miss Johnson helpfully, would have been maintained through the monthly inter-sibling contact. So lest it be thought that this was a straightforward equation between losing a placement with his older half-sibling and contact his mother alone, there was a raft of family support and family contact in this country that the local authority, with the mother's agreement, was putting forward. And there is, of course, the point that my Lady Justice King made, which I had missed from the judgment, and so I have checked it, that this was an approved long-term foster placement. This was not, therefore, one of those cases where one looks at the potential for a child to have to move post-final order, and potentially, worse still, to be separated from the half-sibling with whom he has been placed.
That's what's slightly troubling about paragraph 307, when the foster relationship is described in generic terms, not by reference to the long-term nature of the actual relationship.
My Lord, that's correct, because the actuality of that relationship, its nature, its support, not just the fact that the older half-sibling was there, is of course an important part of welfare exercises, not I accept in every case, but in, as here, a case where that child has been placed there for a substantial amount of time, it is necessarily part of the welfare exercise, because it is A, a positive, and secondly, it is a potential risk of harm for the child losing it.
Well, it's the stability, is, I think somewhere referred to, the stability is provided for the child, which has significantly helped the child develop to where he is now. So you're removing stability, and the judge doesn't analyse the risk of instability.
My Lord, yes, my Lord preempts effectively.
Sorry.
The penultimate point I was going to make. This is not simply a case in which we say the judge was wrong to approach what I would say was a risk-laden venture by placement in Italy. It was also wrong for the judge to ignore the risks that flowed from removing the child per se from the placement in which he was and the contact that he had.
So the assumption that there are, quotes, well-known disadvantages in 307,
again, generic.
Generic and not necessarily related to the facts of the case. In fact, maybe inconsistent with the facts of the case.
Well, my Lord, that is the last point that I'd like to visit in any detail at all, which is this. My Lord Justice Moylan observed earlier that there was, if you like, a false balance here. If I may go one step further and argue this, what we see in the judgment isn't so much a balance at all as a record and analysis by the learned judge of the positives of placement with the father on the one hand, as against a critique or account of the negatives of placement in the UK, some expressed in generic terms. Those at the risk of repetition allow the child to benefit from ongoing stability and have contact. My lords, my lady, the only other point that I raise in the skeleton argument, and I'm not sure that I need to touch on it, is this, which is the use of real by the learned judge. When I say the use, firstly, there is the recital of it at all. One well understands, and it is right that it should be set out. There is clear case law. It is in the bundle. I know it is not in dispute, so my apologies that it was put in there. My apologies equally for going beyond the practice direction vis-a-vis skeletons, where I have set out, because it is so crucial, the passage from Lord Justice McFarlane's judgment. I do so because it is vital to an understanding of where the judge strayed. Because if, without taking my lord and my lady to it now, given shortness of time, I can say this. The reason that case came before Lord Justice McFarlane was that Mrs. Justice Russell had overtly and expressly applied a natural parent presumption in her judgment in the court below. I argue that although that word is not used here, if one looks at how the learned judge expresses herself, but perhaps more importantly, the way in which, as my learned friend for the local authority puts it, the way in which there is a linear analysis. There is, this is what is good about Italy, this is what is bad about the UK. One sees precisely the same error, if you like, being fallen into. And it may be, and I don't invite my lords and my ladies to trouble yourselves now, to look at the subsequent paragraphs, the last couple, which I hadn't referred you to
So
in Re-H.
just take that. We'll just go to those. I think we've time to go to those. We're talking about Re-H, aren't we?
We are. I have this in
Tab 5.
Thank you. Electronic bundle, pages 1.1 and 1.2. And it's paragraph 88 onwards, in which the appeal judgment sets out the misappropriation of Re-L as a welfare factor rather than, forgive me, welfare, relevant to welfare law, and makes the point, and I'm sorry for also referring to a speech given by the President was in a subsequently, where he says that the proportionality exercise is very much the other side of the coin. And he makes that point in this judgment because after the paragraphs that I have referred this court to, there is at paragraphs 93 and 94 a very helpful analysis of how he says Justice Russell fell into. And he says there, well, he sees a prominent observation during day one that Re-L was her starting point. I note those words because I would say that that is precisely what this judge tees up Re-L to be in her judgment. And then at paragraph 94, this case did not turn on the deployment of presumption she describes. This point was not taken within the appeal. My attribution of some prominence to it is not therefore determinative. It solely points out the need for caution. And Lords, my lady, he goes on there at the end. In this context, in my view, it is not apt to refer to there being a presumption in favour of natural family. Each case falls to be determined on its own facts in accordance with the proportionality approach. So that is the point that I say the learned judge fell into error because she went beyond that. In terms of moving to the Article 33 issue, only very briefly, with deference to others on this, I have, in the hope that it is of some help, we have, forgive me, drawn my lords and my ladies' attention to the redrafting or recasting, as they put it, of Brussels to revise, because it specifically deals with something that previously troubled us so much under Article 56. Whether or not that is assistance to this court, I'm not sure, because I equally well understand that by my learned friend for the local authority and indeed Mr. Stoner vis-a-vis the guidance under the 96 Hague Convention. But I do note this, and it's a point that was raised earlier with my learned friend for the local authority. We place within other local authorities all the time. We don't always do so under the terms of public law orders. This court will know that sometimes the provision of supporting a new area might indeed fall under a child in need plan under Section 17. And the court's inquiry in those circumstances will inevitably be fact-dependent. It will not be any private or institutional, to use the terminology, placement. But the court still needs to know what's going to happen, how it's going to happen, how it's going to work, and if things go wrong, what the safety net is. And the difficulty here is that none of that information was available. There were, in my submission, if this court is not of the view that the learned judge was plainly wrong to make the order that she did, and therefore to adjourn this for further consideration, which is not my primary case, it would have been open, firstly, to this learned judge, as my learned friend's already said, to have required a further assessment from Italian social services. But may I also note, in response to an issue raised earlier, that it would also have been open to this learned judge to say, well, the local authority has shown its hand. I know what their case is, but I'm going to direct an independent social worker. I've got the father coming across here regularly. I want him to have time to read the judgment again and reflect on things. I'm going to allow, to come back to the timescale point, a limited number. I want you, the parties, to find a social worker who can do this within the next 6 weeks. And then I will have a final hearing, at which my determination in relation to where this child is placed will take place. It was not, therefore, open to this judge, in fact she doesn't seek to do so beyond noting the delay in general terms, to say, well, this is going to build in inordinate delay if I don't grasp the nettle. The problem was that the nettle that needed to be grasped, which was assessment of how the father responded to her findings, simply wasn't.
So that step you say was critical, because if she'd performed that step and got the additional information, she would then have been in a far better position to balance the interest of the father and with the present position in foster care.
Well, my lord, quite so. And the problem she had, of course, and it's a point that we make, forgive me for repetition, is this. A balancing exercise by a judge, or indeed the judge's findings in relation to the welfare interests of the child, is only and can only ever be as good as the evidence which he or she has. If that evidence is missing, then clearly it is likely that the judge will fall into error because of the lack of it. My lord, also, it was open to the learned judge. I'm really just covering my bases here, so my lady and my lords have it, to indicate to the local authority that she would like to see work towards rehabilitation with the father, whether that was by way of urging the local authority to review his care plan or adjourning on interim care orders for a fixed period of time. That too would, or potentially could, have plugged a quite clear gap in this case.
That sounds like you're submitting that there would need to be a rehearing if the appeal is successful.
My lord, I understand that. No, I am not. I am saying, for the reasons that we've set out in our skeleton argument, that the evidence in this case was in fact overwhelming because of the positives for this child in this jurisdiction, as well as the obvious negatives. In my submission, although it would have been open to the judge to seek further clarification by way of a risk assessment, it is overwhelmingly clear on the facts of this case that it was, as the guardian of the local authority within a very lengthy hearing, having themselves had the advantage of hearing the evidence and considering matters, changed their position and urged on the judge a placement in this jurisdiction come what may. In other words, whether the findings were made or not.
Simply on the basis of the findings that she did make about the father. That is propensity for violence, propensity not to be reliable and so on.
Yes. My lord, with those findings, we say it's all the more overwhelming. My lords, my lady, can I assist any further?
No, thank you very much, Mr. Sampson. Yes, Ms. Cameron. Take your time.
Thank you, my lady.
Yes. We need to turn up your skeleton argument.
Well, my lady, perhaps in a moment, it may be, given the focus on assessment and what the court had before it, I will, if I may, start there and focus there so that we can then build from that point.
Certainly.
Because the submissions have a theme that the assessment that the court had before it at the point that the final report came in from Italy was inadequate, but it is said. And then it is said that indeed the court performing its own assessment, essentially in the course of the final judgment and hearing, that the court didn't have the relevant information. There was a gap of assessment of crucial aspects, not least risk, before the court could come to those conclusions. So in the light of that, although I have 5 areas of submission, I'll start with adequacy of assessment. The second will be to address the welfare exercise relating to the siblings, though that fuses easily into the welfare proportionality necessity balance, which is number 3, which my written document has a great deal of, if I might say, granular detail about. So I wouldn't necessarily go through the facts more, some of those points raised now.
Yeah, we have obviously read your very detailed skeleton argument.
I'm very grateful. Thank you, my lady. I will then deal briefly, but again, these do fuse into the welfare balance, the treatment of domestic abuse and risk, and then the support services from Italy, the point that's likely in the light of the assessment points to also be the slightly longer point. So if I may turn to adequacy of assessment. Assessment is a process and not an event, and that's clear from the Working Together to Safeguard Children Guidance 2023. Indeed, it is said in that guidance at paragraph 162 that social work assessment must be a dynamic process, not an event, analysing and responding to the changing nature and level of need and stroke or risk faced by the child from within and outside the family. It is rightly said by Moylan of Brem, Mr. Sampson, King's Counsel, that the social work team here domestically had the primary obligation for that assessment, but in circumstances where the person to be assessed is abroad, the provisions of the 1996 Convention and the services supported by CACU to provide assessments to this jurisdiction provide the mechanism. However, it still doesn't take away from the social worker's ongoing need to assess. They bring that information in from the foreign state, that which they receive, and then they look at the whole as to what it is required for them to come to a decision, to be able to make clear recommendations as to a care plan in advance of the hearing, and as we know, when this went on for so long, to revise that at a later stage. That fits entirely with the dynamic assessment approach, and of course means that the responsibility remains at all times here domestically to look at the level of assessment and to fill in any gaps, as to borrow a phrase from a learner. So the Italian assessment, in our respectful submission, was part of the jigsaw. It was not the entire picture. Just some obvious points that have been made in other case law in relation to these types of assessments. They are often seen, and we know from the CFAB guidance that they are often seen to be more brief than perhaps one would see in assessments here. But brevity doesn't equate to inadequacy. And nor is this particular assessment inadequate. There were 5 sessions undertaken to produce it. A wealth of information obtained about the father and his family in Italy. But what you have before you appears to be an analysis or conclusions. I recognise it doesn't set out, as you might see in an assessment here, the content of the interviews, other than in the most short form. If I may just briefly look at what the Italian social worker said she was assessing in it. In the supplemental bundle, you will find a note of her evidence that, agreed by our respective juniors, the transcript, unfortunately, would have taken us too long, and it was very important that this appeal stayed in its listing, so we can only apologise for an agreed note. But if I might say, in the supplemental bundle, page 4 of that. Sorry, I apologise. In fact, yes, page 4. And then about two-thirds of the way down, a question by AH in the middle, specify exactly what documents you received in relation to the request of the assessment. And she identifies what she was told that she was to do, which is to carry out a social work evaluation in depth, considering accommodation, housing, work and family conditions of the father of the child and the paternal grandmother.
So not a parenting assessment.
No, I'm just pausing for the translation. I'm conscious I'm going very quickly. I apologise. It's my natural state, I'm afraid.
I think we're all guilty of that.
With the purpose of evaluating their possibility of looking after this child. So that was the request, which she goes on to believe she fulfilled. It wasn't a parenting assessment, and your ladyship has already identified, you've been taken to it, that had an in-depth parenting assessment been required, there were services available to them. So just, if I may, once again, I'm just pausing to allow interpreters to catch up. So upon receipt of that assessment, which we know is dated the 17th of January, no party, not least the local authority and the social workers who carried the duty to ensure that they had all the relevant information by way of assessment before them, identified a need to go back and ask for further assessment, or to focus in assessment on parenting, or knowing it was composite hearing to look at risk. No one went back to send the conviction information, or to check if the domestic abuse matters that they had sent in a statement had been addressed. So mother's Italian statement to the Italian police, they'd sent it through a CACU, the appellant, and if it hadn't been addressed in the statement, nobody went back. That is in contrast to what they did with the second respondent father's assessment from Romania when that was received. And you will see in the judgment a reference at 241. It's perhaps not necessary to take you to it, but it's for your note, electronic bundle for the core bundle 105, that there was a further request for assessment of the second respondent father when the local authority, supported by the mother, identified it as inadequate because it did not address his trafficking conviction. So there was plainly consideration as to what was needed more. We respectfully submit there was a difference here, that Mr. C, the father, was coming over to England every month from May 2022 for multiple days and was here. And it may be, though it's unclear, I recognise, that there was therefore information capable of being gathered, because what we had, and I will come to it in a moment giving you the exact number of hours, was ongoing parenting being observed for multiple days over multiple hours every month by social workers in this jurisdiction through contact. I'll come back to that in a moment, give you the number of hours. So there was some additional information which was available to them. But what also happened is that despite the position, they had, the local authority by the 7th of March 2023 had had a number of those contact sessions since May the year before, and a number of hours to observe the family, the father and child together. And nevertheless, whilst they recognise in their statement there are a number of gaps, they did feel able to address some of the information and come to at least a provisional conclusion. So if we perhaps have a look at the assessment, the statement that was filed by the local authority, it's 435 of the main bundle. Sorry, I'm taking you into this meat of it, but you will find it starting at 432. This is essentially the final statement, the social work evidence template, which you're familiar with, my lady and my lords. And so at 435, there is an observation about what it is that the local authority were concerned about the assessment in Italy. It's in the middle of the page. Father's assessment to care for C had been completed, you'll see. Perhaps if I just give you an opportunity to read that paragraph. My lady and my lords. And then there is an acknowledgement, a paragraph below, that in relation to the fathers, there is no evidence about to fully measure the impact of their alleged lifestyle on the children and risky lifestyle choices. And over the page, in the middle of that box, it says if findings are not made that father is involved in criminality, will he poses an ongoing risk to C, then he should be returned to the care of his father in Italy. if findings are made to indicate that C will be at risk of harm and greatly impacted by the father's lifestyle, then it is proposed he remains subject to a care order and placed in long-term foster care. Now, I just pause there to note that, quite rightly, the social workers identified it's not merely the presence of the findings, it's the linkage of the findings to a current risk of harm and greatly impacted by the lifestyle of the father. There is then an analysis over the page by the local authority social worker at 437 of risk and protective factors. And it's quite properly set out that it's in the last line of the first paragraph that it's difficult to fully determine risk and protective factors due to the number of allegations and different accounts of the parties. But then in the course of that analysis, they do go on to set out the appellant social worker goes on to set out the protective factors in relation to risk in relation to this father. So that's the last paragraph you will find over the page on 438. There is then an analysis of the parenting capability over the page starting at 439 by the social worker in the UK, and that's actually the section relating to this father is at 440, but you'll see the heading. And you'll note there what they said is lacking in the second sentence, without reference to the police disclosure in Italy causing him to serve a prison sentence. There is no analysis, and all of the information relied on self-reported. This is not in-depth, detailed analysis, parent assessment, which delves into the father's ability to care and meet the needs. They then give a next paragraph which sets out...
Don't those paragraphs actually just repeat what has been said previously?
Forgive me, they do, but they're under a section of this social worker undertaking her analysis to the extent that she can, and the next paragraph deals with what they've observed in contact. And then they set out over the page the realistic options. Sorry if I've detained you too long on that, but my point then is, at that point, the local authority identified that they needed to fill the gaps. And we respectively submit that
Can I just point out one other passage at page 44, on page 441? And we mustn't forget this is March 23, isn't it?
Of course.
The paragraph, second to last paragraph, local authority would, however, assert that some order would be necessary in order to provide support and oversight of the children in a country they have not resided in for some years. So that was identified as a...
Yeah, sorry, I was going to deal with that under support.
Don't worry,
but yes,
I
have highlighted that to bring to your attention. I'm sorry, I cut myself short when there was an intervention about me labouring the...
Don't worry.
I recognise I was labouring the statement, but
yeah.
It is an important point because, of course, and I don't, in fact, I rely on it, that there was a clear recognition by the local authority that there need to be some order and some support and oversight, and then there's a process set up to obtain that. I draw to your attention, though perhaps you don't need to go to it straight away, but on this point, that on the face of the main report from Italy, it's headed Articles 33 and 34, and your lord, my lord will know, my lady and my lord, that Article 34 is the provision for services and transmission of information. So they plainly had in mind placement and provision of services when they did that assessment, and there is further information then gathered in the oral evidence of the Italian social worker. So if I may just then look at what happened after this statement. There was then at that point 2 further assessment sessions directly with the father in the UK, one by the social worker and one by the guardian, who stated in her report in terms that it is to fill the gap, she met with the father, to fill the gaps in the assessment. And that was made known in court that this was going to happen, and it was set up to do so. So that you will find, first of all, the first in time, perhaps it's better to do it chronologically, is the 4th of April 2023. And you'll find in the Guardian's report, at 470 to 472 of the core bundle, paragraphs 58 to 67. And perhaps go to that.
Massively out of date by the time it came to trial, and so was supplemented by the
Well,
position
I will
statement.
come to bringing it up to date. I'm going to take you through the chronology to show exactly what went on, but I say it wasn't up to date by the day. That wasn't out
More
to
up to date.
date. Sorry, forgive me. Yes, yes, I recognise.
9 months later, so
Yes.
more up to date.
But one's looking at the wealth of information before the court for the court to undertake an evaluation exercise. And in my respect submission, I'll cut to the end, but I will, if I may, fill in those different points. There was multiple days of evidence of challenge. I'm going to come to each individual in a moment. I'm sorry if I'm being a little slow. I just want to anchor in the documents to be clear, because I do say that the answer to this point is found in a careful reading of the evidence before the court. And what we have here is a guardian setting out that the assessment was short, lacked consideration of early life experiences, relationships and parenting capacity. And the purpose, this is 58, of the meeting was to address the gaps within the assessment and explore matters further. And you will see between my lords and my lady through those pages that in fact the areas that have been identified by the Guardian as lacking are the precise areas of questioning, analysis and evaluation that the Guardian then goes through with the father and indeed his brother, who was present for that assessment session. There was then an assessment session the next day on the 5th of April by the local authority social worker. And you have in the bundle at the core bundle at 453, the write-up, the note, the social work entry in the records, which runs through to 455, it's very closely typed. Her assessment session, which was all before the court in the bundle. And you will also see that what the social worker has done, again on an analysis, it's gone through the areas that she had identified in her statement that she had considered were lacking. We then come to the fact that, though I've said it was monthly, we had before the court the write-up, so there was a question as to, just to deal with what was before the court, there was a section of the bundle dedicated to contact records, as is often seen. All the 2022 records were not in there, but the 2023 records were. And from the 4th of April, the 5th, the 27th of July, the 9th of September, the 10th of September, the 20th of September, then 2 in November, there were over 20 hours of observations of the father and child together in contact. That was over 8 sessions. These contacts ran to 4 or 5 hours. Some where they were on consecutive days were 1.5 or 2 hours. They were extensive periods. They were in the community, and the contact records undertaken by an agency demonstrate a time by time what they're doing at each, very detailed, what they're doing at each point. And it was open, the local authority, of course, as social workers were commissioning and receiving that information, and it was open to them, and indeed, it seems on the 4th of, the 5th of February, the social worker did at least, the 5th of April, it's clear the social worker observed. It's unclear from the records to me that the social worker did observe herself any of those other contacts. So that brings us then to, all that information was running right up to the last one that was in the bundle, was the 7th of November, 2023. That's quite up-to-date information.
Which is where
So they're not in your bundle, they're exceptional
Oh, I'm
contact
sorry, they're
records in the
contact
bundle
records.
before the court. We didn't consider it necessary to burden you with
No, I'm so glad you didn't.
It occurred to me to do so.
But no, I thought you meant that there was another social work note or assessment.
No, so there were these extensive records, and the learned judge had that information. So what we then had is 3.5 days worth of evidence from my client deconstructing his narrative and evidence, and extensive cross-examination about, obviously, the violence that it was said he perpetrated in 2018, and indeed did, on the findings of the court, and then the risks, the threats, and a future placement in his care and risk management. So 3.5 days of him being challenged before the court by multiple advocates on these points, and his responses evaluated by the learned judge. The learned judge then saw the mother in the witness box over 9 days, and that's extraordinary, and I do say that. To be clear, that is extraordinary, that a witness was examined over 9 days.
What on earth did that happen?
I struggle to have got to the bottom of that. It seems that there was, to be fair, interpretation added to it. It does appear, from my understanding, that there was very little interruption. Some of these witnesses gave evidence, particularly the mother and Mr. R. Mr. R gave evidence in chief for 3 days. He's not allowed to do that. We have very long answers, I understand. But so what we have is 9 days of evidence from the mother herself, where the same process of deconstructing her allegations, a challenge about Mr. Costa, her view, forgive me, Father, her views about that, and risk management, and her views about how things would look in Italy. All that was before the court. And then we have 7 days for the fourth respondent father, so the father of the youngest child, in evidence with deconstruction of care options, risks, risk management, and he was giving evidence in detail about the third respondent father, my client, and his views on and knowledge about what was going on in Italy. So accumulated material before the learned judge at first instance was up to date in our respective submission. It allowed the father was coming to this country throughout the trial and was here physically during giving evidence for all those days. He was coming to see his son. He was very open to the local authority and available to him. You'll see the conclusions drawn by the social workers and the Guardian, that they found him, that he was open and worked with them. And that aside from his behaviours and the areas that they were unknown to them at that point, because they knew the allegations, but they didn't know if the judge was going to make the findings. But leaving that element, that they otherwise couldn't see reason why he couldn't care for the child at the point at which their first evidence was filed. By the time we get to the conclusion of the case, it's right that their positions had shifted, having heard the evidence. But it's also right that the learned judge heard that same evidence, and the learned judge had available to her the whole rounded position. And the learned judge's investigation was in-depth. I mean, whilst it's shocking to read somebody's in the witness box for 9 days, it certainly does identify a scrutiny and investigation and a depth to the evidence and wealth of material. And what one then has is the question mark of whether or not there was any real gap identified by anybody at that point. And the truth is that the local authority themselves were not identifying gaps. They were saying that essentially the court could come to a conclusion. It's not open to a party to stand before the court and say, my lords, my lady, you can come to a conclusion provided it's in accordance with what our position is. Otherwise, we'll say that there's a gap in the evidence. You have to, in case management, identify at the point at which there remained a gap in the evidence, that there was, and make an application to fill it. If the local authority had genuinely considered that they could not or did not have the information available to them to fill it. And in our respect for mission, the fact that they didn't make such an application at any stage is indicative of the fact that they did consider that over 20 hours of observations of this father and child, the evidence of his family life in Italy as it was now, and current information about him, as opposed to his behaviours which were 2 years previous, albeit his dishonesty in the witness box was very current. The position then is that it is the case that the judge proceeded on the basis of the evidence available to her, was entitled to do so, we respectfully submit, entitled to analyse it, entitled to bring it into account where a gap in, for example, an assessment was identified. So where there are positive predictions in relation to my
Sorry,
client.
can I?
Sorry, I paused.
Can I just ask you this? I'm just looking at the judge's findings about the father. She starts by saying that, looking at para 257, he's not honest, he's manipulative, willing to mislead and deceive, violent, commits domestic abuse. She then identifies gaps in the evidence as identified by the local authority in 262, which is quite a long list of gaps. She then says she accepts this is 265, the assessments are not as comprehensive as they might otherwise be, but she says there is a wealth of information before the court and she's heard extensive evidence. So do we have any statement by her as to what she thinks of the local authority's identification of the deficiencies? And
It seems the learned judge accepted those deficiencies, but it's in the Italian assessment. What the learned judge, because if you look at, forgive me, my lord, at 262,
yes,
the criticisms there, and if you look at the specifics of them, they're all related to the Italian assessment.
yes,
But what the learned judge is identifying then in the paragraph you draw my attention to is at 265,
yes,
is that there is a wealth of information before this court and extensive evidence which goes way beyond any assessments. And in truth, the sort of narrative chronology I've just taken this court through provided the learned judge with much more information than a single assessment by any social worker, however in depth.
But I'm struggling with the fact that the judge made these very serious findings, and I think you would accept that they are, from a child's perspective, they're very serious. This
Yes.
child was exposed to serious domestic abuse, and the judge has made findings that currently, as my lord points out, the father is manipulative, he misleads, he deceives.
Yes.
Now, there is no assessment or consideration when we look at risk in the light of those findings. Mm-hmm. So, of course, there's been great contact. Nobody could possibly say otherwise, and I don't think the local authority have tried to say otherwise. And it's clearly been extremely beneficial for C. But the fact remains, if you're looking at placing the child with this father, it's not all about lovely contact, it's about future risk. And that will involve all aspects of the child's life, including all the losses to the child. And that's just not there.
Well, in my respect for submission, it is. I'm going to, and I've gone through a journey in the skeleton argument of each element, but in particular, at our before I move on to it, I'll say this: it's not simply the contact. The court relied also on.
And he's got a nice house and his mum's friendly. You know, that doesn't help.
He'd having multiple unsupervised contact for many weeks at a time in Italy before the care proceedings. Only a few days before they started was the last one. Sorry, a week or two before they started. And moreover, that there was an Italian court order for shared care, but there was multiple contacts in Italy for extensive periods unsupervised. Yes. So there was only positive information about his ability to care in that respect. This built on it, the contact that was seen here, and supported it along with that seen in Italy. If I may turn to my skeleton argument at this point.
Of course.
At paragraph 35, you will find it at page 53. But it's a paragraph that spreads over many pages because it starts and it is dealing with risk specifically, risk of criminality, risk of domestic abuse. I'll come on to the other points.
Ms Kavanagh, can I just, it's an extremely helpful skeleton argument, and I don't want to undermine it in any way, but it is, of course, significantly over the limit, and no application was made for to be allowed to exceed the 25-page limit.
That's something I can apologise. I apologise for it. It's my error. I should never have done so. Time effectively.
You didn't stop reading at page 25, I promise.
Never considered you would. The speed with which we had to bring this together is not an excuse, but the only.
I merely mention it because it's very easy to slip into. Oh well, it was absolutely fine in that case. So and so went up to 30 pages and no one mattered. It really is because we do huge amounts of pre-reading, and we really need to stick to the practice direction.
You have both my apology and my acknowledgement that I don't consider it fine, and nor would I normally seek to cause any.
Now take us to your list.
I'm grateful. So in the supplemental bundle, I think we have the, forgive me, I think I may have given you the wrong, I should have said supplemental bundle. Supplemental bundle at page
43 is where yours starts.
Yes, paragraph, page 53. And it's...
Thank you. Starts at paragraph 34.
Yes, I apologise for a moment. I apologise, I've just lost it. I found it now. Oh, thank you. So I'm not going to repeat it, but you'll see it at A. What I've tried to do, and I recognise that I am pulling it together from the judgment, but it's all in the right places, I say, in the judgment, but it's not in a list. And what I've tried to do is pull it together into a list, that which I could see engaged with the very real concerns about domestic abuse for such serious findings, and areas where that risk assessment took place. And the learned judge, it's proper with a risk assessment to look at both sides of that. The length of time since criminality, the length of time, what has happened since, but also reminding herself throughout as to the very current findings of manipulation, lying to her, avoiding it, and his behaviours in relation to the mother and the guardian's belief that, although she doesn't make a finding on this, that there may have been some significant manipulation of the mother in fact, just prior to the final, during the currency of the final hearing, though the judge doesn't make a finding. So in my respectful submission, what you have there is the learned judge engaging, in my respectful submission, she does so, balancing the fact that on the one hand, there is no evidence that his current lifestyle involves criminality or antisocial behaviour from the Italian report that they have, not least the fact that he's not known to social services, and there's nothing on the police. They did have his criminal records through the police at the Interpol before the court. There was nothing to suggest domestic abuse after the incident in 2018. But there was evidence, considerable evidence, of his lying and manipulation and denial of those allegations, which I accept he sustains to this day, a denial of those allegations. But what the judge counterbalanced that with is drilling that risk down, as she must, to what is the risk specifically to see now in the context of living in Italy with the father and his mother in the same household as a protective factor, and in a different country to his mother, albeit acknowledging that the mother's plans were uncertain, and it may, even though she said she would stay in England, she may in fact at some point arrive in Italy. What the learned judge does in our respectful submission is take through a very careful look at, for her own understanding, that the risks as she had evaluated them on the evidence before her, at the current point, did not for her consider that for C, in that placement, is likely to be engaged in domestic abuse in relation to the mother and the father in circumstances where, as she had had an assurance before her by the Italian social worker, that they were equipped and able to undertake supervision of contact, and just as here, if that were the position. And indeed, I'll come to it in a moment, but you'll see on the child arrangements order that was drafted, the local authority were going to have complete control of the arrangements for contact, and it was open to them on their risk assessment to have the child picked up and brought to the centre, and the father never indeed meeting the mother, just as it's open to a risk assessment in Italy as to how those arrangements will take place. It was not the learned judge's contemplation that it would be the father and the mother in a contact centre themselves. Her contemplation would there would be, with a competent authority in Italy, a thorough risk assessment of how those arrangements should take place in circumstances where they had the benefit of her findings of fact, which under the 1996 Convention they are bound to apply. And it's right, isn't it, that it's not for the learned judge to identify what management is required in a contracting state. It is for the competent authority to undertake the risk assessment themselves on the facts that are presented before them with the wealth of information they would have had, and go on to devise the plan.
Sorry, I'm not sure I follow that.
Forgive me.
No, I'm just not sure I follow that submission. You're saying there is a fundamental difference between a placement in England, where the court would have to undertake that sort of evaluation, and a placement in another country where the court doesn't, because it passes over responsibility to another authority. I wasn't quite sure.
No.
It sounded as though you were just saying the court doesn't engage with it at all and says...
I wasn't, and if I sounded like
right.
That's not what I meant. What I meant was the line that is carefully drawn between the court and the local authority's responsibilities here. Just deal with it as if it was a domestic setting, but perhaps in another area of the country where they were reliant on another local authority area. The situation is here that the local authority would receive this judgment that they would undertake their risk assessment as to how we're going to set up contact and where we're going to have it, and is it inappropriate, for example, for the parents to come into direct contact with one another? Should it be that the child's collected directly from school or direct from the parent, the resident parent's home, and brought to the contact by an independent party, like a contact worker? Those sorts of contact evaluations will take place, but what a court very often here would do would not prescribe to the local authority how they manage the care order that they had, for example, or the arrangements that they were providing under a Section 17 commitment. That the court would identify that involvement of the local authority was required, and if a local authority, as here, was willing to provide support services to manage contact, such that then the court would leave the risk assessment of whether that could be managed to the local authority, having considered that the court here would know the services available to a local authority, would know that it's possible for local authorities, as they do all the time, to pick a child up from a foster carer and drop it to contact centre so the foster carer and the parents don't come into contact. The court knows, because it has a wealth of experience, about the sorts of arrangements that can be made. What the learned judge here was doing was, having heard evidence, there's no suggestion that there wasn't similar sort of resources available there, in terms of there was a commitment to supervise the contact.
When you said there was a commitment to supervise, my recollection of the evidence is it was sort of along the lines of, well, we will do whatever is required in a very general way.
No.
Was it?
Yes, there was a specific reference to supervision of contact. Perhaps I take it.
That we are able to, that we will do it? Or, I mean, you make
yes,
it sound as though...
subject to a request.
that the court sort of abrogates responsibility for ensuring that what the court considers would be necessary to support something happening is, on the balance of probabilities, likely to be available.
But the court explored what was available, and it was explored before the court in evidence. In my respect for submission, what you wouldn't have in a case if it were here and not a foreign local authority coming before the court, what you might have here is the court considering, is this a case in which I'd need to make a care order, for example, to secure certain services, or is this a case where I might need a child arrangement order because I've got a commitment of services from the local authority, and the learned judge would know what sort of services a local authority could put in place. A learned judge would prescribe that contact needed to be supervised, but would not necessarily go on to do a deep dive into how you're going to do that, where you're going to do it, who's taking the child. That sort of aspect is the line between the evaluation of proper public authority role and the court's role to trust the local authority to undertake the right, to provide the right services in accordance with its assessment of risk, having received the court's findings and the court's evaluation of overall risk posed to the child. So
Can I just check about that, the contact evidence, and make sure that I've got the right bit? Ms. Kavanagh, sorry to cut across you, just while it's in my mind. I think I'm looking at a supplementary bundle in the note of the agreed note of evidence at page 6. In terms of future contact for D, is it right you were not asked to assess how this would work, that this is an area you could offer assistance? Answer, together with counselling services, could provide supported and supervised contact with the child.
yes.
Father didn't oppose the idea of the child having a relationship with the mother. Is that the totality?
That is one reference.
Is there more? If I missed
I'll
some?
just double check if there is. It may be that there is.
No, I'm happy to accept I may have missed it.
Sorry. Yes, page 5. I'm sorry, I had highlighted another one. Yes.
That was about a parenting assessment.
Yes, I think that is.
Oh, and support to the family, it says. Well, we don't know what that means.
Yes.
The antepenultimate paragraph MC,
Yes,
starting on territory.
that's about the support generally as opposed to
Yes, I think that's right.
specifically. Forgive me, I had thought there was another reference, but if I just very brief, I'll just make sure that. Yes, no, my lady's right. The only reference that specifically says support.
No, that's most part. I just wanted to make sure that I was
is the one that you have identified at 6.
And we know the counselling services are a separate service, aren't they?
Yes, but that yes. Yes, I mean that's essentially both an evaluation of parenting capacity and the potential for counselling, the services to support the family, which the learned judge does in her judgment talk of work to be done, services or work, stroke or work, and so it may be that is something that she had in mind, but we don't know. So forgive me,
No, forgive me, I cut across you, but I was concerned I'd lose track of that bit of evidence.
No, forgive me. So where there is an element where a line is properly drawn. The difficulty for a judge sitting in this jurisdiction dealing with services that might or might not be available in a foreign jurisdiction is the same knowledge as to what is likely to be capable of being available to a local authority, and the sorts of things a judge can just trust to them on their assessment of risk is not always known, and that's why it was quite important for the learned judge to have heard from the Italian social worker as to the sorts of things that were available. And it's right that the learned judge was satisfied that that she had before her a willingness to supervise contact, subject to properly the request for services going through ICACU formally at the point of the child being transferred, and subject to their decision as to which services should be put in place. And they had been clear, and the social worker had been clear, that the directions of the competent authority would be followed. So the learned judge prescribed supervision of contact. And if one goes to the actual order that was, we understand, approved but not made yet, you'll find that in the main bundle at 480. And the first few pages, of course, are the usual preambles and warnings. But at 482, the order itself starts.
Sorry, 4.
In the main bundle at 482, the order starts.
Mine's at 48.
Mine's at 48 too. If we're talking about the same order, I assume.
No,
Order
not. There's two orders that were made. One was the order that you have, the sealed order, but there's an additional order, a child arrangements order, which is entirely separate, which was put in at 482.
Sorry, excuse me.
Which, just in the light of the fact that you may not have considered that carefully, I'll perhaps just take you to the first page at 480 because that explains its status.
Proposed, approved, order approved.
Yes. So it's been approved by the court, but will be endorsed administratively upon completion of a plan, a transition plan. So dealing with 482, which is the substance of that after the usual generic warnings, there was the lives with order at paragraph 1, but perhaps that can be rectified later. And then the child arrangement spending time with. And the obligation is placed at paragraph 2 on the father to ensure that the child spends time with the mother no less than 3 occasions a year, no less than 3 times per year in Italy, supervised by the Italian Children's Services. Now, I noted immediately there's a drafting error there because the judge's order was all contact should be supervised, so even that in England should say supervised. But it matters not.
Well, it does. Such time in England is to be supervised by the local authority.
Well, yes, but the drafting error comes because, of course, as you've already pointed out, my lady, there may be a time-limited element to that part. Doesn't obviate the need for contact itself to be supervised. So there needed to be clarity in that drafting, and that could be this isn't an order that's yet been made, and I'm sure those matters can be rectified prior to it being formally made administratively. But yes, paragraphs 3 and 4 are the key paragraphs. Perhaps if I just provide an opportunity to read them. But they both provide for a risk assessment by the local authority here if they are to relax any supervision requirements or add more or change it. And then in paragraph 4 that the slight difference being that contact centre or in the community depending on the assessment of risk by the Italian Children's Services. Now I pause here to note that since May 2022 there have been extensive contact between the father and the child assessed in the community, and the mother's contact had been from the beginning of the proceedings adapted, assessed and carefully managed. So this local authority in the domestic in the UK had plenty of information and had an ongoing risk assessment process, whereas the Italian social services contemplated would undertake a risk assessment about how that contact structured, and I requested to do so, and then again the usual call if there were to be changes. So in my respectful submission, the actual structure of the orders themselves provided for a protective structure to look at the management of the adult relationships through the supervision of contact and any risk assessment about how that contact should be and where it should be. And that would inevitably include who came into contact with whom.
There's a slight chicken and egg. Like I'm just going back to what the local authority had identified as gaps in Mr. Chiecci's evidence. If that evidence had been plugged, I suppose the judge says it was plugged, this is 265, but if that was the reason that she made the order then, building upon what she assumes was an adequate evidence about the position in Italy, she then makes orders for what's going to happen in Italy, involving the Italian authorities. Sort of the a priori question is whether or not she had sufficient evidence in the first place ever to make that order. It's slightly putting the cart before the horse. And I'm just, again, just looking at the gaps in the Italian evidence and looking at the transcript that you took us to earlier, it's plain that that hadn't been done. And just looking at what she then said, I mean, it's not clear why she thought that she had sufficient evidence, just given what she found about him and what she said were the gaps. I mean, that's really the perhaps where I think it said by the appellant she went wrong.
Well, my lord, in our respectful submission, the position is that the focus on the Italian assessment alone is in error.
You can't really plug that after the event, can you? By saying, let's assume for the sake of argument it's treated as deficient. It doesn't resolve that by saying there will be Italian supervision later on, does it? Because you have to have that assessment to make the order in the first place.
Well, in my respectful submission, it does, and it does so this way. Okay. Because if this was not an Italian placement, but a placement here, what the judge was identifying was that the provisions of a local authority properly complying with its duties of safeguarding to a child, with the usual risk assessments and then provision of a plan in place, would meet the needs of this child if it was here, and indeed, in our respectful submission, in Italy. It's about whether the level of risk exceeds something that can normally be provided by a local authority who is committed to provide services under a private law order, and the learned judge evaluated that it didn't. The plugging...
Did you say it boils down to this? One, she had sufficient evidence in front of her, but two, if and insofar as there was a gap, the order plugs the gap in terms of risk.
Well, the judgment itself would be, and of course findings of fact, and indeed evaluative considerations under the convention are to be considered by the competent authorities of the other state and to be worked with. And indeed the Italian social worker on multiple occasions in her evidence said we will follow the decisions of the competent authority. And the competent authority here with the court, in this instance, sending to the Italian authorities the judgment, as Moylan and friends said it would, first of all pausing for a transition plan and initial responses to how that could be managed, the move. But in addition to when there, the order itself invites them to undertake a risk assessment as to how to manage that contact.
But it's not just contact. I mean, you've focused for a significant period of time now on the issue of contact. It's not just about contact. It's about everything.
Yes.
And one of the things that I'm concerned about as well is you rightly take us to the judge saying there's further work to be done. But I don't see in her judgment any reference to what the Italian social worker was saying is, yes, well, you know, if we get the further information, i.e. the findings, which were in fact made, then further inquiries could be made. But he was asked how long it would take to carry out further interviews. And they said, very busy right now, if referral to counselling services even longer. And I mean...
The gap in the evidence at that point has been, in our respectful submission, the duty for the gap in the evidence before the court for the risk assessment to take place it's a contribution by the Italian authorities for what they could provide. The question is, was it before the court or not to allow the court to come before to the decisions? And I've taken you to the case note. The social worker did assessment sessions before and after contact with the father and the uncle to go through matters and fill gaps for herself. Where the guardian did that, and the guardian, you will see on her analysis, was satisfied she'd filled those gaps. The area of gap which was very important was findings and risk. And what the learned judge had before her was a wealth of information over 2 weeks of people being cross-examined day in, day out, about these issues in front of her, along with all the information of observations of contact behaviours towards the child, time when he was unsupervised in his care, where he is now in his life in terms of his antisocial and social behaviour, and drew together the strands as to what level of risk that was, and in our respectful submission did undertake an evaluation and concluded that that was a manageable level of risk with the sorts of services of supervision of contact and the usual safeguarding duties that a local authority would have with a child placed in its area.
Thank you. Now, where have we got to? We've taken you out of your...
Not at all. Perhaps if I just double check so I don't repeat anything and move on. Yes. Might I just deal at this point, because it's logical for your notes in terms of just how I was on contact, with the question you asked my learned friend about what would happen after essentially the care order for the elder boy ceased, in terms of was there any real consideration as to the financial arrangements or the specific arrangements, because the supervision order for the youngest child may well have gone well before that also. In our respect submission, the child was going to be under care order, the elder child, till he was 18. That the care order lasts to 18. So the services, the duties remain on the local authority to ensure contact with his family, particularly his brother, which is a very important relationship. So that gets us to 18, but in any event, he was an eligible child, and so up to the age of 24, he's entitled to support services to help him sustain all of his relationships.
Yes, well, yeah. I'm aware of that, obviously, but I'm also aware of funding.
But the alternative side of the coin is this, that C, of course, would have been brought into this jurisdiction for contact every month, and would be a child in their area, and the local authority's duties in respect of him would bite. And even if they didn't under Section 17, it was open to the Italian social services, the child who would then be habitually resident in their area, to make similar requests for services under Article 34, as the judge was requesting of them in Italy, of this local authority. And in my respect submission, it would be difficult for a local authority who'd run this case this far to say, if their risk assessment of the mother here was still that contact needed supervising, and the Italian social services ongoing risk assessment was it still did, then it would be very difficult for a local authority here not to say under Section 17 it was entitled to provide those services, or indeed through Article 34 it matters not. So in my respect submission, there is no gap, and you'll note in the order there's a slight difference in that the local authorities is time limited to the care order. Indeed, I'm unsure how that's been allowed to be agreed, because their duties don't end at the end of the care order, but one would have to just look at the drafting of that. The Italian social services can make a request, but in any event, it says that the arrangements...
That proposed order, sorry, just at 4.8,
yes,
whatever it was, had the Italian social service confirmed that they would... have they seen the order and agreed to there being an order for them to supervise contact? And cover the costs of it?
No, they're not required under the order you'll see to cover the cost. It's requests, as is normally in an order. The request, of course, had the evidence before of the Italian social worker saying, yeah, with a proper request through a CACU, we can do this and we would do this. What she didn't have, of course, the learner judge, was the formal request hadn't been made, but that was coming in the transition period. But under that order, the arrangement was different for the Italian side of it. It was to, forgive me, I'll just get the... Yes, the wording is in paragraph 4A, any issues arising in respect of costs charged by a contact centre or generally in respect to the contact shall be resolved between the parties and Italian children's services. So when it says parties, it's not specific to my client, but that was part of the transition planning in our
Thank you.
respectful submission as we read it.
Thank you. That's helpful. Thank you very much.
Thank you. If I may, I'm going to deal more generally, given the time, with the balancing exercise. I'll incorporate siblings and have dealt with risk in any event through the course of our exchanges, and our written document deals with a cross-referencing exercise in the judgment, which I'm not proposing to go back through. But just on the overarching points, a care order is an order of last resort. That's re W. The care proceedings functions of the court and the local authority, 2014 to FLR 431, and we have set that out with the information at paragraph 58 of our skeleton supplemental bundle 62. But the reference goes on by Lord Justice Ryder to look at Lord Neuberger's dicta in Re B, which we again have set out in full in paragraph 58 of our skeleton supplemental bundle 63. But it's paragraph 77 of the judgment, and the key issue is that it seems to me inherent in section 1.1 that a care order should be a last resort because the interests of the child would self-evidently require her relationship with her natural parents to be maintained, if no other course was possible, unless no other course was possible in her interests. There is also then, in the Supreme Court's approach, consideration to the least interventionist order, and and a care order in circumstances where it's a removal from one's parents, a continued removal from one's parents, and long-term professional care away from your family, is a highly intrusive and interventionist order. So whilst those aren't a presumption, they certainly are a point at which there is to be focus under Article 8, under the proportionality and necessity test. Is it necessary for a child?
There's not a presumption. How does it fit with the welfare balance to describe something as a last resort? How does it impact? Does it change the welfare balance?
No, it falls with the proportionality and necessity are part of the welfare balance. And indeed, in Re W, the President identified that they're the other side of the same coin. Even if that's not even if that isn't the case,
That's
they
just
are
adopting
nevertheless
the words from Article 8, proportionality and necessity, or the Convention words. If you're undertaking a welfare balance, you identify the factors in favour and against, and the judge will give those factors the weight the judge considers appropriate in the individual circumstances of the case.
Yes.
So how do the words, when you're undertaking that balance, a care order should be a last resort, help? If it's not a presumption, if it doesn't impact or change the welfare balance?
Well, indeed, the Supreme Court themselves have dealt with this. The Supreme Court identified that the welfare balance is a proportionality exercise and a necessity exercise, and so perhaps we've set it. We didn't put it in because we considered it to be so well known to this court, but Re-HW, and in my paragraph 33 of the supplemental bundle at 52.
Yes.
I know my learned friend has done a similar exercise, but looking at the provisions, their paragraph 45 in the Supreme Court is that a care order, I mean, this isn't a direct quote, but it largely is, it can only be made even if the threshold is met if the order is necessary for the protection of the child's right to go free from harm proportionate to the needs of the situation. The aim must be to make the least interventionist possible order, so it fits squarely with their dicta of Lord Neuberger in Re B, who identifies that last resort is not simply a question for adoption, it's a question for care orders, because Section 1.1 of the Children Act.
But the question I still have, is how does this impact on the welfare balance? How does it practically, if you're trying to explain to a judge, how does that practically impact on the welfare balance when you're looking at what is in the child's best interest?
That has to be a cross-check against whether it's the least interventionist order to meet the welfare needs of the child. And if a care order in long-term foster placement is too high an intervention because there is a family placement that on the learned judge's evaluation of the evidence could be made safe enough, then in those circumstances, the balance would fall in favour of the least interventionist order, which would not be removed from your family till your majority under a care order. It would fall
Isn't that a
to...
presumption in favour of the family? You have to ask, so what's the least interventionist in the case of a child who's been happily, stably in care for the last 2.5 years, as against removal to Italy? The counterfactual is 2.5 years of stability in care. But you're effectively saying if you can place the child with the family, that trumps 2.5 years worth of stability. That does weight it, doesn't it, in favour of the family?
I don't say, forgive me, apologise. It's about the order and the intervention in the child's life. And the reality here is a lifetime in foster care, and I'll come in a moment to why I say the judge did deal with specifics, moreover had specific problems with the foster care placement before her, not just generic. But here, in circumstances where, if let's say one had a child who was very settled, had almost, for example, as foster care wanting to become a special guardianship, so the issue of permanence was likely to be off the table, and stability of placement was likely to be off the table, that compared to a parent would look at what's the least interventionist model order, and it may be that the conclusion isn't it's the natural parent, whilst that would be part of the Article 6 balance that would have a significant weight. It wouldn't be one that would be be outweighed by a circumstance where permanence on a less interventionist order, such as a guardianship order, could be achieved by committed carers here where the child's been settled. So it doesn't always lead to the natural parent and the family being presumption. It's an issue of the less interventionist model of care and looking at whether that's right for the child on the balancing factors.
But I'm struggling with the use of the expression least interventionist in this case. The order, if the child moves to live with his father, will be very interventionist. It will have a significant impact on the child's relationship with his older brother, sibling, with his younger sibling, with his mother, with other members of his family who live in England. So it is a very interventionist order. So how can you use the expression least interventionist in the circumstances of this case?
Because when one's undertaking an evaluative balance of the interventions of each type of care that's being identified, it's not simply, my lord, of course, for those factors, it's not simply reading a care order, ergo, that's the highest intervention. The Supreme Court are looking for that might be a last resort, but it might be the last resort that is in the welfare interests of the child from the other evaluative factors.
I don't understand why it's called a last resort. Even it has factors in it which might warrant a decision that type of care, that form of care, is in the child's best interest. Why is that a last resort? Well, how would you describe it in the circumstances of this case a last resort?
Because here the court had evaluated that there was a parent who could care for a child whose care could be made safe enough with the Italian services on the evidence before her, and was looking in comparison to that as to whether or not the child should move to that care or stay where it was. And in circumstances where the order of the child staying where he was would be a lifelong till he's 18 and under a care order, in circumstances where he wouldn't live with either parent on the face of it, where he wouldn't necessarily be living with his brother after a period of his brother leaving care, and his brother's rising 14, so 4 years or so, and in circumstances where he would, and I do say, and I'll go to it now, that the submissions of all the parties, I've set it out in the skeleton argument, looked at some of the evidence before the court that the foster care had indicated that if both boys weren't to stay, because they share a room, and this was a two-child placement, that they may not be able to continue the care of the elder boy. And that's in the submissions. It's part of the evidence before the court. So there was potential for instability of permanence. There is always potential. That flags, even if it doesn't come to fruition for the older boy, or C, because he would have been in Italy if that scenario came through. What it flags is that these are professional carers who can retire at a certain point, who can give notice because of behaviours of another child. And the source of all of that evidence was the together and apart assessment, which had interviewed the foster carers, had interviewed the children, and looked at some of those in real terms, problems of potential instability for this child. So that is part of being under a care order in professional care, specific to this case, not just generically. And when one's looking at whether that over and above another placement, I don't say one has magnetic attraction. What I do say is, as per the Supreme Court, that the evaluation is of trying to find the least interventionist order for the child, and that could be, because of all the factors you identify, of course, that it would be least interventionist ultimately to stay in foster care in the UK. The learned judge didn't conclude that, because the learned judge concluded that actually foster care in the UK had some significant disadvantages for this child, including the potential for, and a real potential, we say, for the loss of, if not the damage to, the relationship with the father, which was very important.
There's no question of losing the relationship.
Well,
unless the father, just said, well, if you can't live with me, I'm not going to have anything to do with him anymore.
So the position we have actually is we say that there was a real risk, and the learned judge had evidence before her of that. What you had was a local authority who didn't in any way prioritise the father's relationship, or, and the judge said, undervalued the importance of it, because their care plan endorsed by their independent reviewing officer was 2 times a year contact, down from the monthly contact, which was, as you've heard, 2 days, 4 hours a day. So this child would have a day out, or a couple of days out, twice a year.
Could the judge make a contact order?
Could have made a contact order.
Could the judge make a contact order?
She could.
Yes. Would that address that point?
No, because the maximum, my lord, the maximum that was being suggested by any professional was 6 times a year by the guardian. If the judge could have potentially, as she did under the other father's order, asked the local authority to reflect on her judgment, come back to her with their responses to her proposals for contact, and if they were not satisfactory to her, make a contact order. So that same model could have been followed. But here, it demonstrated a concern about the local authority who had the powers under the care order, after the order was made, to prioritise and understand and respect the importance of this relationship. The supplemental the submissions included, and I put this in the skeleton, so again, I don't wish to take you to it, but this foster care had stopped providing progress reports and photographs. They said that they didn't want any more parental gifts from the father. There was a natural, we submitted in our closing submissions that this was indicative of the father's relationship being diminished and a risk of him being airbrushed out of the child's life. The judge acknowledged that there did appear to be evidence before her, so it's a risk of airbrushing him out of the child's life. That was not
just take us to the judgment where she finds
so
that.
That's,
we've had the 2 references
yes,
where she said
me,
that be lost. Just take us to the analysis of the
yes.
of that. Just can't remember where I find that.
Sorry, I'm being told. I'm very
281,
grateful.
did I
Paragraph
overstep?
113. Paragraph 281.
Thank you.
So
Right, lovely, thank you very much.
I'm
That's
grateful
lovely.
to my learned friend. And then at paragraph 282, you were taken to the comment that it's unthinkable that he should lose the relationship with his father, which is so positive. In our respectful submission, that the judge acknowledged and accepted that understandably the father was worried he was being airbrushed out of the child's life, but actually when one properly, meaningfully engages in what that plan would have looked like, what you find is an absence in its entirety almost by the local authority and the Guardian of what it looks like to him in terms of his relationships with his paternal family. He would not have been in foster care travelling to see his paternal family. And that was a family in which he had had very meaningful contacts, being there 3 weeks over the Christmas before he went into care, completely unsupervised. So there was a deficiency that the learned judge found in the local authority's approach to that relationship. And in our respectful submission, paragraph 282, where the learned judge talks about it's unthinkable should lose that relationship with his father, which is so positive, is a risk that the learned judge is identifying as a result of the evidence before her. And in our respectful submission, those are also very proper factors to go into the balance of looking at what the right care for him is. And indeed, the learned judge ultimately came to the view that indeed the contact with the mother could be supported by orders, and the child living with the father would give him the best prospect of stability. And in our respectful submission, that stability was key to the finding of the court. I'm
Thank
very
you. Is that
conscious
a-
of the
is
time,
that a
so I'm going
convenient
to pause
moment?
there. I will review over lunch and hopefully
How-
try and...
How much further have we got to go?
Indeed, that's what I was proposing to review, because it may be that I have very little, because we have, of course, my 5 points, we've gone...
I know we've sabotaged them. I do apologise.
It's,
but,
it's much more
but from
constructive to get to the heart of it. I've no issue.
but from our point of view, that having had the benefit of such a detailed and helpful skeleton argument, it's extremely helpful to us, especially with leading counsel who are well able to respond to questions from the bench.
No, it's much more valuable for us to go to the heart of it rather than to dance around it. So I've no difficulty. Perhaps if I take a review over lunch, it may be that because I have so much in writing on this granular cross-referencing, it may be that I only have 15 minutes, and I'll try and reduce that again.
No, well,
But I'd like the opportunity to reflect.
No, of course you may, and it's most important when you're for the respondent, 1 against 3, that you feel very comfortable that you've had an opportunity to put your case completely.
I'll certainly address the issue of what next,
Of course,
which
that
is
would
where
be-
I'm thinking 15 minutes might be
Well,
appropriate.
please don't feel under pressure, Mrs.
I'm grateful. Thank you.
Thank you. 2 o'clock, please.
Always.